Let me thank Chairman Capito and other members of the subcommittee and our witnesses for being here today to discuss the EPA's 2015 National Ambient Air Quality Standards for Ozone, colloquially known as NAAQS, and two related legislative proposals. Ironically, this hearing comes the week the American Thoracic Society, 16,000 strong here in Washington, is in town urging action to protect American lungs from climate change and pollution. In March, President Trump unveiled an executive order instructing agencies to review regulations that affect domestic energy production, which includes EPA's 2015 ozone standard. A few weeks later, EPA attorneys were granted a delay in the ozone standards case, now before the U.S. Court of Appeals for the D.C. Circuit. EPA stated it needed time as, quote, EPA officials in the new administration will be closely scrutinizing the 2015 rule to determine whether the standard should be maintained, modified, or otherwise reconsidered. Despite all this administrative activity, we are here today talking about bills to delay implementation and formation of health standards for ozone and other pollutants. Why is that? The answer, I'm afraid, is that there is neither the law nor the science to dismantle the ozone standard quickly through administrative action. So the fossil fuel industry is calling, as usual, on politics. The Clean Air Act mandates that NAAQS be set solely based on what's necessary to protect public health, specifically not on how it affects domestic energy production. The 2015 ozone standard was based on sound peer-reviewed science, and the 70 parts per billion standard was the high bound of the proposed 60 to 70 parts per billion range. EPA's independent science advisors, leading medical groups like the American Medical Association, American Academy of Pediatrics, American Thoracic Society, American Lung Association, and American Heart Association, and public interest groups such as the NAACP had all called for a stricter standard, closer to 60 parts per billion. So winning with 70 was not enough for the fossil fuel industry. State compliance dates are linked to the severity of their pollution. Some states have upwards of 20 years to comply. The Congressional Research Service compiled a preliminary list of non-attainment areas based on state recommendations. As you can see from this chart, West Virginia, Arkansas, Oklahoma, Nebraska, Iowa, Kansas, Mississippi, and Alabama, the states represented by Republicans on this subcommittee, all believe they are already in attainment of the 2015 standard. So why then delay ozone compliance for these states that are already in attainment? I'd like to ask unanimous consent to enter the CRS material into the record, Madam Chair.
Without objection.
Polluters never want to reduce their pollution and regularly attack the Clean Air Act based on overblown costs that always ignore the other side of the ledger, the public health and other benefits of reducing pollution. Well, my state is on the other side of that ledger. We're downwind of the polluters. For years, tall, upwind, out-of-state smokestacks have been launching ozone-forming pollution into the prevailing winds that carry it to the playgrounds and backyards of Rhode Island. Rhode Island parents shouldn't have to tell their children they can't play outside on what looks like a perfect summer day because it's a bad air day caused by out-of-state upwind pollution. In evaluating proposed ozone legislation, I encourage members of the subcommittee to take both sides of the ledger into account, including the substantial public health benefits of reducing pollution. Madam Chair, I'd like to ask unanimous consent that a letter from my Director of Environmental Management, Janet Coit, and 4 other northeastern states be entered into the record in opposition to the proposed legislation, that another opposition letter from 22 public interest groups, including the Appalachian Mountain Club, the National Parks Conservation Association, the Nebraska Wildlife Federation, and the Wilderness Society, be put into the record. Without objection?
Oh, without objection.
An opposition letter from 15 state attorneys general and the District of Columbia's Attorney General and the acting secretary of the Pennsylvania Department of Environmental Protection be put into the record.
Without objection.
And finally, that an opposition letter from 14 health and medical groups, including the American Lung Association, the American Thoracic Society, the American Public Health Association, and the Asthma and Allergy Foundation of America, be put into the record.
Without objection.
Thank you, Madam Chair.